We can start. Honorable the Chief Justice of India, Justice Suryakant, Honorable Judges of Supreme Court and High Court, past and present, Mr. Manu S. Pillai, dear family members of late Shri Ashok Desai, and we have in our midst Mrs. Smita Devan, his sister, Mr. Harsh Desai, an advocate with distinction practicing at Bombay High Court, Ms. Ami Desai, Mr. Jay Desai, coming all the way from Trump land of United States, Mr. Shyam Devan and Mrs. Madhvi Devan. Mrs. Madhvi Devan has set this elegant stage for this evening. Dear chamber colleagues, Mr. Nitin Thakkar, Mr. Vikram Nankani, our chamber colleagues from Bombay, Mr. Krishnan Venugopal, Mr. Justice Pratik Jalan, Ms. Menaka Guruswamy, who recently elected to Rajya Sabha, bringing a lot of pride and new feather to flaunt for the chamber. Menaka deserves an ovation. Welcome. Mr. Darpan Wadhwa, Mr. Ritin Rai, Mr. Parthiv Goswami, Mr. Ashish Wad, Mr. Vikram Mehta, and the spouses. Dear colleagues and friends from bar and outside the bar, it is actually an honor and joy to have company of you all, both those who are actually here and those who are participating virtually. We have a YouTube dissemination. For this fourth Ashok Desai Memorial Lecture. This lecture is in continuation of first Ashok Desai Memorial Lecture by Honorable Mr. Justice D.Y. Chandrachud, then Chief Justice of India, delivered at Bombay. The second one delivered by eminent political scientist and public intellectual Pratap Bhanu Mehta and late Shri F.S. Nariman at Delhi. I suppose last of Fali's public lecture, when he unraveled the doctrine of basic structure with his characteristic simplicity of language and lucidity of thoughts. Third Ashok Desai Memorial Lecture was delivered by Justice Abhay Oak at Bombay. So you'd notice that we have been having two speakers at Delhi in this lecture series. Today this honor and joy is more than doubled by presence of Justice Suryakant, the Honorable Chief Justice of India, and Manu Pillai, an eminent author and historian, because their presence ensures an interesting evening full of stimulating ideas, something which Ashok Bhai would have really enjoyed at this venue. And as most of you know, IIC has been a favorite place for Ashok Bhai. Of course, the red wine to be enjoyed with the stimulating conversation is missing, because today is a Monday, a working day, which is followed by a sudden holiday most of us could not plan. Honorable Mr. Justice Suryakant, the Chief Justice of India, needs no introduction as parens patria, the head of our judicial family. His distinguished career as a lawyer, as Advocate General of Haryana, and as Judge and now as Chief Justice of India is a matter of public knowledge. Also, a high constitutional functionary of it is known more by the judgments and pronouncements, which are always in a big public glare. So let me share one interesting detail about our chief, a detail which was shared in one of his lordship's public speeches, I think Ashok Sen Memorial Lecture. The name Suryakant is inspired by famous Hindi laureate Suryakant Nirala. Our chief is indeed Nirala, a very unique as a judge, always preferring resolution through consensus. Of course, you have to give judgment, then he gives judgment, but that's the first effort. I have addressed His Lordship as our chief because he is always so amiable and so friendly. We are indeed grateful for your presence, sir. May I request Harsh, Ami and Jay to welcome our chief with a plant and a small token of gratefulness. No, I'll call you again. Thank you very much. You'll have to come back again, or you can be on the stage. Manu Pillai is a historian and a prolific author. Still in his 30s. His celebrated works include The Ivory Throne, The Chronicles of House of Travancore, published in 2015. He was in 20s that time. Rebel Sultans, The Deccan from Khilji to Shivaji, published in 2018. The Courtesans, The Mahatma and the Italian Brahmin, Tales from Indian History, in 2019. False Allies, India's Maharajas in the Age of Ravi Verma, 2021. And recently, Gods, Guns and Missionaries, The Making of Modern Hindu Identity, in 2024. There are numerous Saturday columns in Mint Lounge, which I read regularly, and which are always delightful with the wit and humor about foibles of kings, queens, nobles, saints, and commoners of the past, portrayed just as humans. I would particularly commend The False Allies, where Manu has given a very interesting take on administration in princely India. The British needed monarchs and princes as the rulers because the British realized that they were not acceptable to rule these princely states directly because people would not accept them. At the same time, the British controlled these monarchs and princes through all kinds of intrigues and tactics, including branding them as debauched and incompetent by deliberate propaganda. In this challenging situation, a lot of princes still did very well, despite all odds conjured against them by the British. For the welfare of people, they ruled and ushered development, modern outlook, and progressive ideas. And this is a very interesting theme of the book, well documented. Manu has taken 4 such princely states where Raja Ravi Verma stayed and painted, and has given an interesting and well-researched account of this relationship between the British, and the people in those times. For people with amateur interest in history, like I have, Manu in his genre is always so well-researched, without any of the angularities to left or right point of view, and gives irreverent but a very lively rendition of history as if the event of past are unfolding before you here and now. May I request Harsh, Ami and Jay to welcome Manu with a plant and a small gift as token of our love and affection. Of all the things, Ashok Bhai would have enjoyed this twist in the evening today. We have this young man taking us to past to make us reflect on the historical foundation of rule of law through talk on resisting injustice, the Raj, the law, and making of modern India. And we have our head of family. And I would not call him old because we are of the almost same age. And our chief would talk about reimagining justice, the Indian judiciary 50 years hence. There would not have been a better juxtaposition of topics and speakers, and it is now time for me to start the 4th Ashok Desai Memorial Lecture with request to Mr. Manu Pillai to deliver his address.
Thank you very much, Mr. Shishodia. Thank you to everyone who's here, respected Chief Justice of India. And I see that the room is full of lawyers. I don't think, I've done many public events, but I don't think I've ever addressed a room full of lawyers, packed to the brim with lawyers. I don't know if that's a good omen or a bad omen, but it's certainly interesting. I will say I'm delighted. Let's hope at the end of this lecture you will be as delighted with me. Now, I'm going to begin this talk by telling you the story of a woman called Savitri. It is something of a fascinating tale, and I hope you'll excuse the more naughty or disturbing details. The event goes back to Kerala in 1905. Savitri, or Thatri, as we say it in the more vernacularized Malayalam form, was at the center of a scandal that year. She was a Nambudiri woman from an elite Brahmin community. Traditionally, Nambudiri ladies were supposed to have no contact with men outside of a small family circle. They were Ghosha, that is in Parda. Thatri was also in Parda, and at about 18 she'd been married to a much older man. But in 1905, when she was in her early 20s, she was found conducting an adulterous affair. Indeed, it was not one or two lovers. Some 65 men were named by Thatri. Now, some of these episodes ranged, of course, in a very disturbing way. It went back to childhood abuse when she was 10 years old. Some of them were consensual affairs with individuals of various caste backgrounds, of different classes, before as well as after marriage. The list featured, for example, a brother-in-law, a mahoot, household staff, and even a celebrated Kathakali actor. Now, when Nambudiri women were discovered in such situations, there was a typical method of trial and punishment. It was called the Smartha Vichara, in which a group of elders and caste experts would interrogate the woman and determine the punishment. The important part was to gain a confession, and in addition to sequestering the lady, some coercive instruments were also used. For instance, snakes could be thrown into the room where she was held. This would motivate, to put it gently, something of a confession. Alternatively, if the snake did not harm the lady, it was assumed that this was divine proof that she was innocent and she'd be let free. Starvation, emotional blackmail, etc. were also used. It did not always work. In fact, there's one case in which the woman, pestered with "who else did you sleep with" questions, pointed in irritation at the clerk taking the notes and said him. That said, once a confession was obtained, the woman would be excommunicated and the men would also be thrown out of society. The men would have no chance to cross-examine the lady or argue their innocence. The only option was to undergo a trial by ordeal, where you dipped your hand in boiling oil, and if your hand emerged unscathed, you were deemed innocent. But the Thatri trial of 1905 was occurring at a specific moment in Indian history where old and customary forms were collapsing and new forms of judicial and legal procedure were cementing themselves. First, there was general sentiment. As the scholar Rajiv Kumaram Kandat has noted, and he's done a fine study on this Thatri incident, Smartacharams so far were concerned primarily with caste purity. So if there was adultery, it threatened to pollute the bloodline of this Brahmin community, and that was the concern with this. Now, however, in 1905, there was a broader public involved. People were asking questions around chastity, women's virtues, sexual morality, and things like that, partly also influenced by Victorian notions of propriety. Similarly, while the earlier Smartha Vicharams concerned one community, now with the print media, newspapers and the like, there was a much larger audience, if you will, for events like this. And thanks to colonial era influences and the rise of new institutions, there was pressure for the trial itself to evolve in its methods. A group of caste elders convening together to dispense justice no longer looked good and no longer looked modern. For instance, with Thatri, a traditional Smartha Vicharam was held first. But then the Raja of Cochin ordered a second trial, let's say a more modern trial. Careful notes were taken, the press carried updates regularly, and for the first time, the men were permitted to cross-examine the lady. This mattered because, as the scholar I mentioned has noted, some years before in a colonial court of law, a Nambudri who had been charged in Samartha Vicharam, he was exonerated, saying that the man had never had a chance to cross-examine the lady. The old system could also be questioned in other ways. One of the 65 men was a Tamil Brahmin, and he denied the right of the Malayali Brahmins to try him according to a Malayali style, saying, I'm a Tamilian, therefore this will not work. The sheer variety of castes and individuals involved meant that the old style trial wasn't going to work. So a more modern trial was needed. So the king or the political executive took things into his own hand and decided to do a retrial. And in the end, of course, all these men were excommunicated and Thatri was also thrown out. Of course, to round up the story, she was very meticulous. She remembered the places where she had met the 65 men, often correlating dates and times with festivals, harvest seasons and travels. If the accused denied knowing her, she would list out marks and scars on their bodies, by this substantiating the allegations. A local newspaper said, she replies like a barrister, which is quite something for a sequestered Brahmin woman in 1905. And in the end, all of those dozens of men, excepting one or two who had died, were ostracized. The lady was also excommunicated. Nobody knows what happened to her afterwards. But it was such a scandal that all kinds of stories have since circulated. Some say she was taking revenge on behalf of all Nambudiri women forced to live in Parda. The veil was meant to guard their sexuality, and here she turned it into a weapon and exposed Nambudiri men and the injustices of patriarchy. This reading gives the affair a slightly poetic air, and Thatri is presented as a goddess of vengeance. Another story is somewhat more entertaining. It goes that the Raja of Cochin abruptly ended the trial at 65 names. Thatri had more on her list, it is claimed, but the Raja refused to proceed. Why, you might ask? Because according to local gossip, the 66th name was the Raja's own. Now, I'm telling you the story of Thatri. The point I make is this, that if we think today's system is complex, India's traditional legal landscape was perhaps even more complicated. For one, there was no single fount of justice. In some matters, one might go to the ruler. In others, it might be caste councils deciding according to custom. In certain cases, religious authorities were consulted. But in others, it could just be a group of wise old men. There were cases where Hindus went to local qazis to arbitrate matters, while Muslims consulted Hindu authorities. Regional practice mattered. My favorite historical episode on this count concerns a 17th century missionary and his Muslim attendant. They were traveling through Bengal when they caught a peacock. They were clearly hungry because they cooked its flesh, ate it, and buried the feathers. Hindus, however, saw the peacock as a sacred bird. And so, by killing and casually eating one, these guys had obviously committed a crime. So they were dragged before a Mughal official, where the missionary defended the act. He said that his aide was a Muslim, and as such could not be expected to honor Hindu beliefs. But the Mughal official did not buy the argument. He pointed out that this particular area was a Hindu district. Maybe elsewhere, where Muslims dominated, peacock murders could be excused. But in this region, that was unlawful. In other words, what was or was not a crime varied by locality. Caste too mattered. In the Deccan, for example, drinking was not considered a serious crime with the lower classes. But if you were, say, a priest, you were likely to be judged more gravely. For the priest was held up to higher standards than an inebriated farmer. One-size-fits-all rules were not the norm. The same applied to fines. In many cases, you could get off by paying a fine. In fact, dispensing justice for pre-colonial Indian states was a major source of income. Colonial era figures would later argue that this system was misused by the well-off to get away, to get scot-free, and that it was the poor who suffered. But there is enough to suggest that the picture was a little more complicated. Fines under the Peshwas in Maharashtra, for example, depended on the party's background. Very often, for the same crime, different people paid different fines. For the exact type of sexual misdemeanor, for example, one man could be fined as much as 7,000 rupees, which was pretty large in the 18th century, while another was fined only 90 rupees. What mattered was the ability to pay. In the first case, the individual was wealthy. In the second, the man was poor. Yet in their respective contexts, the figures decimated their finances, and so the punitive principle was met. Finding the rich man 90 would not have made sense, and finding the poor man 7,000 would also have been unreasonable. Indeed, in one case, there was a cowherd who was not fined money at all. Instead, he was made to part with 20 kilograms of ghee. Of course, there were ways to bypass these situations. To go back to the peacock murder in Bengal, the original plan was to amputate the hand of the man who had slaughtered the bird. But after payments were made to the Mughal official's wife, a case of judicial corruption as it were, punishment was amended to a simple whipping. Painful and exemplary, but not quite like losing a limb. If I'm allowed a cheeky joke, I'll call it a review petition via financial incentive. In any case, the spectrum of Indian law involved everything from trials by ordeal to jury-style panchayats. Some legal practices stemmed from superstition, while at the other end were famed judges of integrity and character. Consider, for instance, Ram Shastri Prabhune in Maharashtra in the late 18th century. In his storied career, he dealt with all kinds of cases. In one, the issue was caste. A group agitated to be recognized as Kshatriyas, while local Brahmins branded them as Shudras. Prabhune, a Brahmin, went against a lot of caste pressure to actually side with the claim to Kshatriyahood. In a property dispute, similarly, one of the parties insisted that the paperwork should be examined behind closed doors. Prabhune refused. He said, "We are not going to look at them in a corner because then doubts will remain. If we do not look at the papers before the assembly, it will be nothing but the work of thieves." An interesting thought in a time when sealed cover jurisprudence is much debated in India. Prabhune was not perfect, of course, but emerged as a judicial icon by sticking to the loftiest standards of his time. Indeed, in 1773, after the ruling Peshwa in Maharashtra was murdered by his own uncle, who then declared himself Peshwa, Prabhune actually said that the proper punishment for this crime was death. He said to have left Pune when the uncle took over the administration, returning only after the latter was expelled from power. Today, we'd probably term this a great example of judicial independence, and I have a feeling that Ashok Desai in particular would have approved of Ram Shastri Prabhune. So the good and the bad, the strange and the rational all coexisted in India's traditional legal systems. With the British acquiring power, though, this fragmented and decentralized judicial style went into terminal decline, and an increasingly uniform structure emerged. At one level, it was inevitable. As modern state structures, institutions, centralized governance, and so on came into force across vast swathes of the subcontinent, decentralized forms could not efficiently serve these altered circumstances. The transition was not easy, nevertheless. The British, for instance, assumed that Hindus could be subjected to legal prescriptions from their scriptures, prioritizing written normative texts over the practice on the ground. The result was often confusion. As late as 1870, for instance, a white judge spoke of the grotesque absurdity of applying strictures from Sanskrit texts to castes and tribes that had entirely different practices. Another suggested it was the justice of the tomb, like a German trying to administer law in 19th century England using a 500-year-old Latin manual. Yet the British were quite determined to manufacture consistency and persevered. As aliens, a centralized legal framework was more convenient for them than the complex reality that existed on the ground. Additionally, the British could also claim that they were restoring ancient traditions in India. It made them look good to hold up Sanskrit texts and argue that the Hindus had forgotten their own real laws, and so now the white man was here to help them go back to the correct way of things. It was a manner of legitimizing their own power and presence in India. While Indian society adjusted, as all societies do, this did have social repercussions. For instance, my own ancestors belonged to a caste group in Kerala called the Nayars. The Nayars were matrilineal with succession in the female line. Men went to their wives' houses after marriage, and children inherited property from the mother. Among the Nayars, the marriage was a very simple ritual called sambandham. The man would give the woman a cloth in front of a lamp, and that was it, no further fuss. Divorce too was easy. My great-great-grandmother in the 1870s or so dismissed her first husband and took a second. When the man showed up one morning, he was simply told he was unwelcome. In the 1820s, the then Maharani of Travancore similarly gave up her ailing consort. It was too inconvenient, he was quite ill, and chose the next one from a parade of 7 suitable candidates who were presented to her. Interestingly, Sambandham also made inter-caste unions possible. For instance, the Ranis of Cochin always took Nambudri Brahmins as husbands. They used to get 6 and 8 rupees for the job. But in the 19th century, as marriage came to be defined along scriptural, shastric terms and norms, Sambandham suddenly seemed like it lacked scriptural shastric backing. The result was that these matrilineal groups were told overnight that they were not practicing marriage, but a form of concubinage. That is, whether you were the queen of Cochin or my great-great-grandmother, you did not deserve the term wife. It caused, understandably, a great deal of umbrage. Now, if I add to this the fact that polyandry was also not unusual, that women could have multiple husbands, you can imagine how that looked in the Victorian age when everything was according to the Shastras. Now, these developments in law were also occurring against a broader set of political and structural changes that British power was triggering in India. Law, after all, is also very dynamic, and its nuances of interpretation and reinterpretation can mirror societal changes more broadly. So just as knowledge of Sanskrit texts became key to colonial era legal innovations, knowledge in political, administrative, and financial terms was also central to cementing this new state structure. And Indians, understandably, resisted in various ways the advent of this empire of knowledge, and by extension, more meticulous state control. Let me give you an example. Today we take maps for granted because we live in a world where everything is mapped out in detail. I looked at the map to guide my Uber here today to this venue. But when the British began their great trigonometrical survey over 200 years ago to map, triangulate, measure, and assess India's physical landscape, there was great opposition. After all, as harmless as mapping sounds, in the process, the colonial state was also accumulating knowledge on soil types, which areas were fertile, which were not, where the major forts were, what jungles Indian rebels could hide in, and so on. It was for this reason that surveyors often needed military protection. For example, a group under James Garling in the early 19th century was resisted by armed men serving a local Raja. Survey activities to people then looked akin to, say, officials now suddenly intruding into our personal homes. Indians also objected to survey flags because sometimes it looked like an affront to the flags of local states. Ordinary folk were sometimes just confused. One scholar records how certain villagers assumed that surveyors were just convicts. They were measuring roads as a form of punishment. But the Raja's suspicions were probably the bigger point. Measuring the road, after all, also enabled the British to recognize exactly how long it would take to move an army to his capital. And his suspicions were not unfounded. In fact, at one time, the British even sent men disguised as Buddhist pilgrims to Tibet. They would count steps with prayer beads and estimate distances to reach specific towns and points. Naturally, in this time of change and flux, Indian responses were creative. In hard power, the British were dominant, so recourse was taken to what are called weapons of the weak. There's an essay that Shishodhyaji wrote about Mr. Desai, in which he says that Mr. Desai used to say that we will fight with what we have. It's a bit like that. That is, deploying whatever else is available to a subject race to preserve as much as possible of their own existing ways. For instance, under their treaty with the British, the princely state of Jaipur in Rajasthan was obliged to hand over a part of its revenues to the British if the revenues ever exceeded 40 lakh rupees per annum. It was written down, signed, sealed, and understood as an abiding contract of sorts. But the Maharaja obviously wasn't very happy with these terms, given that it entailed considerable loss of power and revenue. So what did he do? He simply and coolly fudged his accounts. In 1871, Raj officials suspected that Jaipur's revenue was somewhere between 50 and 60 lakhs per annum. Officially, though, the Maharaja declared it at exactly 39 lakh rupees, tauntingly under the milestone at which he'd have to start paying the British. When they insisted on a salt monopoly, in which Jaipur would have to close its salt works, the Maharaja agreed. But then he also ensured another clause was there in which the British would have no right to inspect his salt works or confirm that these closures were done. Indeed, as late as 1906, the all-powerful British Empire in India had no complete picture on Jaipur's finances. In nearby Udaipur, it was more or less the same. The British pressed the Maharana Fateh Singh in the late 19th century to modernize, to bring in railways, construct new roads, upgrade financial management, and so on. But the Maharana refused and got his way for decades. To begin with, under the new order, the Raj had the legal right to confirm all successions in the princely states. Fateh Singh was actually an adoptee. The previous ruler had died with no legitimate heir. And the British would have preferred a younger man that they could have manipulated. But the Udaipur Darbar just went ahead and adopted this older man without even waiting for British approval, presenting a fait accompli. Once in power, Fateh Singh was jealously protective of his rights. If the British wanted railways to be expanded in Udaipur, he would take years to agree, and then only after extracting something in return. In this particular case, it was the expulsion, I think, of a pro-British minister. He refused to maintain troops that could be commandeered by the Raj. When they wanted him to come to Delhi to bow to the British king in 1911, he invented an illness and got out of it. And most importantly, the state accounts of Udaipur were maintained in an old-fashioned style. This was not only due to the Maharana's refusal to modernize, but out of a strategic calculation as well. Modernized accounts could be deciphered by the British easily and would make colonial interference and surveillance over Udaipur more likely. Keeping his books in the old style made imperial oversight more difficult, and through this allowed the Maharana greater autonomy. It was a way of shoring up his own power despite the reality of a stronger suzerain. While this is how political figures navigated change, ordinary Indians were also learning to manage colonial era developments. Indeed, they would find ways to turn even instruments and technologies of the Raj to their own advantage. The railways are a case in point. They were meant to knit the country together, enabling movement of goods, the transportation of troops, and so on. As such, they were visible proof of British power. This is why in 1857, during the Great Rebellion, for example, railway stations were attacked by the rebels. And this is also why the princely states did not want railways extended into their territories. But in only a few decades, the same railways had a variety of unforeseen effects that would negatively impact British interests. Pilgrims, for instance, used the railways to travel distances that were once formidable. Where back in the day, this meant fewer people ventured to these sites, ease and speed of movement now enabled larger and larger numbers to travel. In the process, temple coffers got fuller, local economies received a boost, cultural exchanges of an organic nature grew at an unprecedented pace, also creating avenues for cultural assertion against the white man. Consider just the example of Mahatma Gandhi. He was no admirer of modern technology in general, but he used the railways to bring India closer together. When he traveled, every station where his train stopped opened up an opportunity to interact with people. Indeed, even if only for a few minutes, the railway station was transformed into a political pulpit, and the rail network into a medium to energize Indian nationalism. Where the Raj looked at trains as instruments of their power, originally, these were gently subverted by subject people into a means to express what the British called sedition, and we called nationalism. Nationalism in India, in fact, emerged through an interesting interaction between the old and the new, through a selective appropriation of colonial-era ideas with pride in one's own culture and a yearning for freedom. In India's constitutional history, we see Indians in the 19th century already pondering over these questions. Dadabhai Nauroji, for example, is best known for his work on the drain theory and for becoming one of those unusual brown men to win an election to a parliament of and for white men in Britain. But few know that in the 1870s, he was briefly Diwan or Chief Minister of Baroda. He saw Indian-ruled states as spaces for Indians to demonstrate that they did not need civilizing by the British, that Indians could also govern in a modern style without imperial oversight or interference. The British were not very pleased, as the colonial resident in Baroda said, despite his excellent knowledge of English customs and habits, Nauroji was actually pursuing a very Indian cause. In Baroda, he attempted to introduce ground rules for modern administration, limiting the ruler's arbitrary powers, streamlining finances, attracting talented and qualified public servants instead of relying on hereditary nobles, creating a settled legal landscape, and so on. All of this was intended to serve as a blueprint for future constitutional rule. Elsewhere, Indians trained in the secretariats of the Raj transferred their services to princely states, helping their rulers run better administrations. In many cases, princely governments in Mysore, Travancore, Pudukkottai would actually exceed in standards their neighboring British districts. Here again, the larger point was this. If in Indian-ruled states the administration surpassed that of British districts, the colonial state would have no leg to stand on. Indians would have proved that they could rule without foreign guidance. These dynamics, by the end of the 19th century, would allow Indians to make a watertight case for nationalism and ultimately freedom and self-government. Unsurprisingly, a vast majority of nationalists making this case were lawyers, men and eventually women, trained in the British system, deploying British origin terminologies and concepts, often in British-controlled public spaces, but for Indian causes. British-inspired legal systems, meanwhile, also unleashed new forces in India. For instance, in 1868, Savitribai Phule, the social reformer in Maharashtra, heard of a local scandal featuring a Brahmin boy and a Dalit girl. The two were in a romantic relationship, and when this came to light, the villagers were about to murder them. In keeping with local custom, they were paraded first in shame around the village. I rushed to the spot, Savitribai wrote later, and scared them away. Scared the mob, that is, by pointing out the grave consequences of killing the lovers under British law. It was an important moment. Though British law, as I mentioned earlier, triggered several complications in India, in many respects it also created space for individual liberty to emerge, for new notions of freedom to rear their head, and for discrimination along caste and such traditional norms to be challenged. Resistance, that is, was not a tension between brown people and white rulers alone. Among brown people also there were injustices, and here also new dynamics were in play. It can be said with some confidence, in fact, that while there had always been criticism of caste in Indian history, and while there were great dissenters across the country, just think of Bhakti poets, for example, in the medieval period, the colonial era opened room for the first time for new kinds of political mobilization among the marginalized. But here again, what is interesting is this. Many social reformers like Jyotiba Phule, for instance, went to missionary schools and read English texts like Thomas Paine's Rights of Man. Yet they then used these concepts and ideas not to reject their Indian identity, as the British sometimes hoped, but to reinvent, reform, remake, and reinvigorate it. I always think, for instance, of the advent of the English language in India. Many calculated on the colonial side that English education would make Indians more loyal to the British, that it would transform our character. It certainly changed many things. Even today, Indians are dependent on the colonizer's grammar book to communicate with each other across the divides of region and our many local languages. Indeed, Indians show tremendous appetite for English. There is a story, for instance, of a single street in Madras having some 100 boards advertising English language classes as far back as the late 18th century. Of intellectuals in Bengal upset that the British had established a Sanskrit college, going and pooling money to establish an English college. While many were motivated by the possibility of obtaining jobs in the British services, there was more to it. For English opened up access to new knowledge, new ideas, and new possibilities, which many Indians then adapted, as I said, to the Indian context. It was, for instance, a bit of a scandal in 1841 in Bombay when a man called Bhaskar Pandurang published 6 letters, which perhaps constitute among the first seriously articulated Indian critiques of colonial rule. What is interesting is that Pandurang wrote this in English. They were published in an English newspaper and deployed Western concepts and terms familiar to India's colonial rulers, except it was against them. In other words, Indians were not mimic men, even as British power elevated new forms of legal thinking, language, and political formulation. They appropriated these new forms, creatively reimagined and innovated on them as Indians, and redeployed them for their own purposes. In a sense, they slowly seized weapons from the outsider, showed the outsider the door, and envisioned thereafter a new India for themselves and the future. I began this talk with the story of a Malayali woman, and I'll end it now with the tale of another. In the 1920s, Travancore state in Kerala was under a regency. The person in charge was a lady called Sethu Lakshmi Bai. She was only in power for 7 years and faced many challenges. There were British officials supervising her every act, reporting on every decision to bureaucrats in Delhi. There was a husband who had his own ambitions and a tendency to try and control her, like many husbands to this day. There were politicians who claimed she was a puppet in the hands of said husband, and they never ceased to attack her. The press too doubted her. Even her minister saw her as just a woman, as it were, expecting her to be a figurehead while he ruled the state. Add to the fact that she was personally a shy and reserved woman and not prone to grand radical statements or confrontations. So on the face of it, she was destined to go down as a failure and someone forgettable. And yet, despite all the pressures, she persevered, and in small doses delivered lasting change. For example, when she came into office, the only women in the Travancore government were nurses and teachers. By the time she left, over 400 women were employed in the administrative services in a space of 7 years. When she came into office, women had no place in the legislature. She created space for them and nominated the first members. 100 years ago, this was a big deal to have women in the legislature. While magazines wrote that women who received modern education, and I quote, were negligent in the performance of domestic duties, Sethu Lakshmi Bai upgraded the Women's College in Trivandrum, allowing girls to study science, mathematics, and serious subjects. Most significantly, given that you're all essentially a legal audience, it was in her day that Travancore saw its first female law graduate. A decade later, that woman would become a judicial officer, and you'd all have read of her as Justice Anna Chandi. Sethu Lakshmi Bai ruled under many difficulties, but whenever she could and wherever she could, she quietly did her work, undramatically managing every pressure she confronted. And as a consequence, years later, even when she was no longer on the scene, someone else was primed to make history, making use of the mechanisms she had set in place. So I'll end with that message, that sometimes in the most challenging of moments, in times of change and unpredictability, you don't necessarily need to espouse big and grand events. Small acts of resistance are adequate. Sometimes your presence is adequate. And if enough are able to summon up the ability to lead small changes of this order, eventually the little rivulets and streams they create will merge into something more magnificent. After all, among the many things history offers is one substance that has always kept human beings going. And that special thing is that little thing that we call hope. Thank you very much.
Thank you, Manu, for this delightful and at the same time very educative and interesting perspective. And friends, let me share one small secret. It took a lot of persuasion to convince Manu to come and speak today. And I really feel vindicated in a way. And there was one interesting principle in the matrilineal system, that a matrimony was a matter of fact and patrimony was a matter of opinion. And if I can just add one story from Jodhpur, one of the ancestors of my wife's side, he was teaching the Maharaja, young Maharaja, who was in his 20s, and there was a murder in the Riyasat, and the judge said, no, I would convict him, and if you want, I can resign, but I can't betray my conscience. The English resident was equally keen that the rule of law should prevail. So this teacher advised Maharaja that let them do their job. You are a king, you can pardon them. So after the conviction, those murderers were pardoned. Now, so we have the good and bad, as Manu said, in the ancient system, and also, but we are lucky that we are living in a time which is more consistent about rule of law and governed by a constitutional system. And it's time now to travel to future with our Chief Justice. May I request Justice Suryakant, Honorable the Chief Justice, to deliver his address.
My colleague, Justice Prasanna Varale from the Supreme Court, very respected former judges from the Supreme Court, Sister Justice Indira Banerjee, Brother Justice Ajay Rastogi, Justice Hemant Gupta, Justice Rishikesh Roy, my colleagues from the sitting judges of various high courts who are present here, former Chief Justices, former judges of the high courts, Mr. Pallavi Sisodia, Senior Advocate, whom I give credit of organizing today's event, and of course for inviting me. A galaxy of senior advocates, additional Solicitor Generals, Mr. Manu Pillai, author and historian, the family members of late Shri Ashok Desai, his sons Mr. Harsh Desai, Mr. Jay Desai, his daughter Ms. Ami Desai, and his sister Smita Diwan. Young members, members of the legal fraternity, members of the Bar Association, ladies and gentlemen, today I am especially looking forward to sharing my views on a subject that I find very exciting and, quite frankly, one I have not had the occasion to reflect upon in this manner before. When I was searching for today's theme of discussion, Sisodia Sahab helped me. He suggested me 3-4 subjects. But some of those subjects I have been speaking a lot as a part of my responsibility in legal service authority, judicial academies, high courts, national law universities. From the perspective of the bar, then I thought that let me speak on a subject where imagining something when I am not sure that what will really going to happen, but thinking 50 years backward, I just try to develop some ideas that what's going to be the face of the Indian judiciary 50 years hence. I believed it was important to pick something engaging and thought-provoking, and this is what I thought this subject should be. That's why I prefer to start it with the most often quoted, our eminent jurist Benjamin Cardozo, who observed that the law, like the traveler, must be ready for the morrow. To put it very simply, the law does not remain fixed. It evolves, it absorbs, it adapts, and gets shaped continuously by the passage of time. All of us are temporal travelers. Yet we often imagine time as a straight and unyielding line moving from past to present and onward into the future. The law, however, resists such simplicity and is not linear. Instead, I like to imagine it as a tapestry. Each doctrine, each precedent, each constitutional value is a thread drawn from history, interwoven into the aspirations of the present, and stressed carefully toward the uncertainties of tomorrow. What we inherit is never static. It is a living fabric that must be interpreted with both memory and foresight. Having reflected upon the movement of law across time, it now apposite that we turn to an individual who embodied that movement through intellect, integrity, and quiet resolve. Shri Ashok Desai, in whose memory we have gathered here today, and was fondly known to many as Ashok Bhai, remains a towering figure whose life continues to illuminate the path of the Indian bar and bench both. Shri Desai was an erudite man who completed his law degree from the Government Law College in Bombay in 1952. Most of you know it, but I thought that the young members of the bar might not be aware. He then joined the London School of Economics and graduated with a BSc in Economics. This varied background helped him immensely, enabling him to wander beyond the narrow boundaries of legal doctrine. He was among the many doyens of the bar that Bombay has bestowed upon the nation, having started his practice there in 1956. Over the decades that followed, his career grew to encompass roles of the highest responsibility. He served with distinction as Solicitor General of India, 89 to 90, and then as Attorney General in 1996 to 1998, representing the nation at moments of profound constitutional significance. Yet to speak of his positions alone would be to overlook the real substance of his legacy. Shri Desai's work was defined by a deep engagement with constitutional principles and an unwavering commitment to the rule of law. His contribution, for instance, in the landmark decision Ramana Shetty, gave powerful articulation to the principle that arbitrariness is fundamentally opposed to equality under Article 14. In Vineet Saran, the Supreme Court's directions strengthened institutional accountability and laid the foundation for greater independence in investigating processes. His role in Narmada Bachao Andolan decision reflected the delicate balance between development and rights, while his appearance in matters such as Narasimha Rao versus State, Amarinder Singh versus Punjab Vidhan Sabha engaged fundamental questions of parliamentary privilege and constitutional limits. Even earlier, in what came to be known as the Back Bay Reclamation case, his work anticipated the emergence of public interest litigation, reflecting a sensitivity to fairness in state action that would later mold an entire jurisprudential movement. These are, of course, only a few specks in a much larger constellation that defines the legacy he has left behind and his forging of Indian jurisprudence. What distinguished him, however, was not merely his mastery of the law, but his understanding of life beyond it. His engagement extended well outside the courtroom into academia, journalism, and international legal discourse. He taught at his alma mater, the Government Law College, contributed as a legal correspondent, and represented India before global institutions, including the United Nations, Geneva, and Vienna. In recognition of his contributions, he was, of course, honored with Padma Bhushan. To those who had the privilege of working with Sri Desai, it is often said that his guidance was marked by remarkable simplicity. In his own words, he would remind them to never celebrate a victory and never mourn a defeat. I must admit that I did not have the opportunity to be enlightened by him after my elevation to the Supreme Court in 2019. I had, of course, long been aware of his contributions to matters of great constitutional significance and of the exceptional quality of his advocacy. Having said that, during my years practicing before the Punjab and Haryana High Court and occasionally before Supreme Court, with a little more frequency when I was holding the office of Advocate General, there were a few matters in which I encountered Sri Desai as my senior opposing counsel. Those brief interactions were sufficient to leave a lasting impression and affirmed what one had always heard about him, that he was a lawyer of the highest caliber and a person of impeccable integrity. As we reflect today on his life, we are reminded that the strength of our legal system rests not only in its institutions, but in the individuals who animate them with their courage and clarity. His journey stands as a testament to what it truly means to serve the law with excellence and invites us to consider how such a legacy may guide the future that lies ahead. In reflecting upon a journey such as his, one is compelled to recognize that Sri Desai was not merely addressing the disputes of his time, he was, in many ways, shaping the contours of a future he would never fully witness. This, ladies and gentlemen, leads us to an important realization about the nature of legal evolution. I am coming now to the subject. The ink used in a judgment does not dry when the decision is delivered. It settles over time, shaped by interpretations, tested against changing realities, and ultimately revealing its true depth. What appears today as a settled principle often finds its fullest meaning only years later, when applied to circumstances not yet imagined. In that sense, the law is always in dialogue with time, continuously unfolding rather than remaining fixed. It is perhaps easier to appreciate this passage of time when we reflect on change in our own lives. In a lighter vein, I recall that as youngsters, we were filled with a sense of wonder at the sight of cars such as the Premier Padmini or Contessa moving along our streets, or Maruti 800 entering the market, or when television sets made the transition from black and white to color. These moments felt extraordinary then, yet appear mundane and ordinary today. At that time, we were told that by the 2020s, which we have crossed, we would be gliding through the skies in flying cars and spending our holidays on distant planets. The reality, as it has unfolded, is far more grounded. The past few decades have witnessed an unprecedented democratization of information. This wide dissemination of knowledge can be directly attributed to the remarkable pace at which technology has advanced, reshaping not only access to information but also the way individuals engage with it. Of course, technology has now permeated every sphere of life, including the legal realm, and with it the functioning of judicial institutions. However, if we cast our minds back to the 1970s or even the early 80s, I myself entered profession in 84, court processes were considerably slower, rooted in a system that was entirely manual and heavily dependent on paper. Judges were often seen seated behind towering stacks of files while record keeping and administrative functions were carried out by hand, meticulously entered into large and cumbersome ledgers. The scenario in lawyer chambers also was not too much different. At that point in time, the bar and the bench had very limited institutional support, and the development of jurisprudence was largely centered around the true understanding of our Constitution alongside civil and criminal law. Despite the constraints of infrastructure, resources, and administrative support, that period produced some of the most enduring decisions in our legal history. Many of the judgments that form the bedrock of our jurisprudence, those that expanded constitutional interpretation and gave meaningful content to the fundamental rights enshrined in our Constitution, emerged from that very era. It was also during that time that the jurisprudence of public interest litigation emerged, opening the doors of the courts to those who had long remained unheard. This I am only pointing out that what happened 50 years back, more than 50 years back. Over the decades that followed, this technological evolution gradually came into sharper focus, moving from something indistinct to a far more defined and integrated presence. We transitioned from typewriters to computers and fax machines, from the rotary telephones to landlines and eventually to mobile devices. Most significantly, the advent of the internet ushered in a digital transformation that reshaped the very information was created, stored, and accessed. The shift from physical records to digital platforms, from paper file to cloud-based systems, marked a fundamental change in the functioning of institutions. Ultimately, knowledge that was once confined to libraries and institutions came to rest in the hands of individuals. Legal awareness, access to judgments, and the capacity to engage with public discourse expanded beyond traditional boundaries, reshaping the relationship between citizens and the law. In the present day, the very idea of technology is often spoken of alongside artificial intelligence, with the two increasingly seen as interconnected in both discourse and application. Within the justice delivery system, such tools are already being utilized at various stages, enhancing efficiency and access in a multitude of ways. Artificial intelligence, however, remains a relatively recent and still evolving development. It continues to be the subject of significant debate, particularly with regard to its capabilities, limitations, and safeguards. While a degree of apprehension is understandable, it is equally important to recognize that we stand at the threshold of a generational shift. With careful design and appropriate regulatory frameworks, these systems can serve as powerful aids, especially in areas that are burdened by repetitive and time-consuming tasks and which do not call for the nuanced judgment that only a human mind can provide. It follows then that the work we undertake today carries within it a similar responsibility. The reforms we speak of, whether in the realm of alternative or preferred dispute resolution mechanisms, or in the transformation of digital processes, cannot be construed as simple administrative improvements. They are the foundations upon which a future legal order will stand. In that sense, we occupy a unique position in the continuum of law, just as we draw strength from those who came before us, so too will others inherit what we choose to build. We are, in fact, the ancestors of a future legal civilization, entrusted with the responsibility of ensuring that what we leave behind is worthy of that inheritance. Ladies and gentlemen, as we stand at this cusp of change, we must confront a deeper and more specific question. If the last 50 years place the world at our fingertips, what do the next 50 years hold, particularly for the Indian judiciary? In my opinion, in a nation such as ours, which is poised to emerge not only as an economic and technological power, but also as a moral and institutional exemplar, the character of justice itself must evolve. Let me be very candid. To stand here and attempt to predict with any degree of certainty what the world 50 years from now look like is not only an impossible exercise, but it also must be somewhat presumptuous. 50 years, when expressed as a number, appears modest, almost abstract. Yet, when one pauses to consider it more carefully, its true magnitude becomes evident. If I may read out a beautiful quote by Charles Colton, you must have read it, but in today's context, the celebrated English writer, he said, it's a beautiful quote for this context. Time is the most undefinable yet paradoxical of things. The past is gone, the future has not come, and the present becomes the past, even while we attempt to define it. If you ask me, the Indian judiciary of the future cannot remain confined within imposing buildings or constrained by geography. It must transform into a service that is accessible, responsive, and seamlessly integrated into the daily lives of citizens. In such a vision, justice is not longer something one must travel to seek, but something that reaches the individuals efficiently, equitably, and with a sensitivity to the realities of a changing society. Our endeavor must thus remain crystal clear to nurture a system of justice which, 50 years from now, is more accessible, more responsive, and more closely integrated into the lives of citizens. And once we accept that our aspiration, the next question inevitably follows, and that will be, what will such a future demand of those entrusted with administering it? What will be the Indian judiciary of 2076 look like, not only in its structure, but in its spirit and in its substance? To begin with, the very idea of a judge will undergo an immense transformation. The judge of the future cannot remain confined within the identity of a legal specialist or jurist alone. The disputes that will come before the courts will require an understanding that extends far beyond statutes and precedents. For instance, I presume they may find themselves grappling with questions of synthetic biology, which may raise liability issues where life itself is engineered, or something as technical as deep sea mining will test the limits of environmental responsibility in spaces that lie outside our idea of conventional jurisdiction. Perhaps virtual communities will generate conflicts between individuals or even entities that are rooted not in physical proximity but in shared digital existence. In such a landscape, the judge of the future will need to be an extremely nuanced and interdisciplinary thinker, capable of engaging with science, technology, ethics, and society with equal ease. Alongside the evolution in judicial capacity, the nature of disputes themselves, I reckon, will change in fundamental ways. Consider the idea of something as intricate and fast developing as digital sovereignty. In the future, Financial transactions may increasingly take place within decentralized ecosystems, governed not by national boundaries but by coded protocols. Disputes arising from decentralized autonomous organizations or interactions within immersive digital environments will challenge traditional notions of jurisdiction. At the same time, there will also come a time when climate concerns will no longer remain within the domain of policy alone. The judiciary may increasingly be called upon to recognize and protect the rights of natural entities, including rivers, forests, and ecosystems that sustain life. The idea of harm itself may expand to include acts that irreversibly damage the environment. If I am to say hypothesize, then maybe concepts such as ecocide could emerge as subsegments to criminal jurisprudence, requiring courts to balance development with the preservation of the natural world in a far more immediate and structured manner. Similarly, we may well witness a fundamental shift in how entire branches of law are perceived and applied. Criminal jurisprudence could adapt to forms of conduct that do not fit within traditional definition of offense. Civil procedure, as we understand it today, may be streamlined or even reimagined to suit a system driven by speed and accessibility. At the same time, personal liberty and fundamental freedoms are likely to be regulated by fundamental duties towards other individuals or may expand in scope as new dimensions of human existence come within the reach of the law. Even areas that presently remain at the margins of mainstream discourse may require unexpected significance. For example, statutes such as law of carriage of goods, which seldom occupy center stage, could become increasingly relevant in a world where goods are transported through drones or autonomous vehicles. The law, in such circumstances, will be required to respond not only to technological advancement but to entirely new relationships and responsibilities that such advancement creates. These shifts will also bring about an administrative transformation of considerable scale. The movement towards a paperless system is already underway, but the future will demand far more than the digitization of existing processes. Evidence may be recorded, stored, and verified through distributed systems that ensure authenticity and permanence. Case records could exist in forms that are tamper-proof and universally accessible, reducing delays while enhancing trust in the system. Technology will also redefine the manner in which judges engage with information. Artificial intelligence, already in its early stages within our judicial system, through softwares like all of you know SWA, SPACE, Liga, will evolve into a far more sophisticated and capable assistant. AI will surely not replace judicial reasoning, but its role will become enormous in sifting through vast volumes of material, identify relevant precedents, and present structured insights, enabling judges to devote their attention to interpretation, fairness, and the human consequences of their decisions. In this sense, AI will act as an enabler of better judgment, not as a substitute for it. Perhaps the most significant transformation, however, will be in the accessibility of justice. The idea that courts are distant institutions, both physically and psychologically, will gradually disappear to a new model that brings adjudication closer to citizens. Virtual platforms may enable the creation of highly localized forms where individuals can seek redress without the barriers of distance, cost, or complexity. The gap between the citizen and the system will narrow until it is reduced to the simplest of interfaces. And I am wondering that what will be the face and structure of the bar. The structure of the bar too is likely to undergo significant transformation. Even today, law offices and chambers are steadily incorporating a range of AI tools to assist with the research, drafting, and various administrative functions that were once carried out manually. It is thus not conceivable that in the next 50 years we may witness a departure from existing patterns where increasingly sophisticated systems assist not only in preparation but also in the formulation of perhaps oral arguments before the court. The possibility of such developments invite careful reflection and, in my view, raises important questions about the role of the bar itself. The essence of advocacy has also rested in persuasion, judgment, and an understanding of human context. As technology becomes more deeply embedded within legal practice, the extent to which the bar adapts to and shapes this transformation will be of critical importance. Lastly, when we attempt to imagine what the next 50 years may hold, one aspect that naturally captures the imagination is the very form and setting of the courtroom itself. As law continues to expand as a field, attracting an ever growing number of young professionals, it becomes necessary to consider how these spaces may evolve. While courtrooms expand in scale, with advanced technology occupying a central role, undertaking routine functions such as calling out matters, recording proceedings, and instantly displaying submissions made by counsel? Or will we witness a more fundamental shift where physical presence becomes minimal and proceedings are conducted almost entirely through virtual platforms? This vision, however, is not without its challenges. Questions of fairness, transparency, and accountability will, I am quite sure, assume renewed importance in a system that relies heavily on technology. The balance between efficiency and due process will need careful calibration. The human element of justice, empathy, discretion, and the ability to understand context must therefore remain at the core of adjudication, even as the tools surrounding it continue to evolve. As we look ahead to this future, one thing becomes clear. The Indian judiciary of 2076 will not be defined solely by technology it adopts or the structure it builds. It will be defined by its ability to remain moved in constitutional values while adapting to a world that is changing in ways we are only beginning to understand. As we contemplate a future marked by rapid transformation, it becomes essential to identify what will keep us steady and tethered. Even today, despite many uncharted paths and testing circumstances that as we as a nation have encountered, the enduring edifice crafted by our founding fathers through our constitution has provided a source of stability. Similarly, I hope and firmly believe that as we will approach 2076, amid the acceleration of technology, the expansion of digital frontiers, and the redefinition of disputes, the judiciary will continue to rely upon the same support system that secure our nation's stability and consistency. For us, the fulcrum lies in essential tenets such as the rule of law, democracy, separation of power, and the independence of judiciary. It is equally anchored in the guarantee of the fundamental freedoms and in values such as ethical integrity, empathy, compassion, and dignity. Together, these principles form the guiding compass of our constitutional order, ensuring that even as institutions evolve, their core purpose remains unchanged. They form the core of our constitutional identity and in difficult times guide interpretation, restrain access, and preserve the balance between power and liberty. This understanding is closely tied to the nature of the Constitution itself. It is not a relic frozen in the moment of its adoption. It is a living and dynamic document, capable of responding to new challenges while remaining rooted in its perennial values. In this sense, the wisdom of our constitutional framers assumes even greater relevance. They did not seek to anticipate every single future circumstance. Instead, they crafted a framework strong enough to accommodate change without losing its essence. Our task today, therefore, is not to reinvent what has already been so carefully designed. It is to ensure that this framework remains its strength and integrity as it carries the aspirations of an ever growing and increasingly complex society. As we draw these reflections to a close, it is worth returning to a simple yet essential truth. Justice cannot be measured only in orders delivered or decrees pronounced. Its real strength lies in the confidence it inspires in the ordinary citizen. As we look to the next 50 years, our responsibility is clear. Even as the law becomes increasingly sophisticated in its methods, it must remain deeply attentive to the human condition. Efficiency must not come to the cost of empathy, and innovation must not displace accessibility. This vision calls for a renewed commitment not only to institutional reform but to culture of justice that remains sensitive, inclusive, and grounded in constitutional values. For that, it is imperative that we begin laying the groundwork today. This is not a moment for hesitation or complacency. It is not the time to say, Kal kisne dekha hai. Before I conclude and take your leave, I must express my appreciation to the organizers for having organized this memorial lecture and thank the members of the Desai family for this wonderful opportunity. It is a privilege to speak in remembrance of a figure whose contribution continue to configure our legal landscape. And so, we conclude not with finality, but with purpose. We are not only heirs to a distinguished past, we are entrusted with the responsibility of charting what lies ahead. Let us build that future with the same sense of integrity, balance, and conviction that Sri Desai exemplified. Thank you very much, ladies and gentlemen. Jai Hind, Jai Bharat.
We are very grateful to our chief, and I must reveal another secret. When I approached him, he readily agreed, unlike Manu, without a blink of eye, to address today. Many thanks for kind words for Shri Ashok Desai. We don't talk in public very high of Ashok Bhai because he taught us to tread lightly in life and laugh more on yourself and among yourself than to talk big. And it's a sign of success of the event today that the hall is over full as it was in the beginning. And you heard a wonderful talk by the Honorable Chief Justice of India, Justice Suryakant. The only constant is change, and he made us think, made us think that what kind of future we are heading as lawyers, as judges, the kind of subjects and issues which may challenge the values we espouse. And now I will request our colleague Mr. Parthiv Goswami to propose a vote of thanks before we conclude.
Good evening, ladies. Good evening, ladies and gentlemen. As the fourth Ashok Desai lecture draws to a close, it is my honor and privilege to propose this vote of thanks. First and foremost, we offer our deepest gratitude to the Honorable Chief Justice of India, Shri Justice Suryakant, for his kind acceptance of our invitation and for delivering an insightful and thought-provoking address on Reimagining Justice, the Indian Judiciary 50 years hence. Your Lordship's reflections have not only illuminated the path ahead, but have also inspired all of us to engage more meaningfully with the evolving ideals of justice in our constitutional democracy. Thank you, sir, for your gracious presence and for readily sparing time from your extremely busy schedule to deliver today's address, which has truly added luster to this memorial lecture series. We are equally indebted to Sri Manu Pillai, who has traveled all the way from Kerala for his erudite lecture on resisting injustice, the Raj, the law and the making of modern India. Your scholarly insight and historical perspective have enriched our understanding of the dynamic ways in which law have both shaped India's evolving journey through time and in turn being shaped by it. Your address has truly left an indelible imprint in the minds of this august gathering, thereby making this lecture truly memorable. This evening stands as a fitting tribute to the legacy of late Ashok Desai, whose seminal contribution to the legal landscape of this country continue to guide and inspire generations. Through this memorial lecture, we not only remember his remarkable life, but also reaffirm our collective commitment to the values he embodied: integrity, magnanimity of heart, humility, and an unwavering commitment and dedication to the cause of justice, civil liberty, and the rule of law. We are deeply grateful to Honorable Justice Prasanna Varale, Judge, Supreme Court of India, for gracing today's function. We are equally grateful to Honorable Justice Indira Banerjee, Justice Hemant Gupta, Justice Rishikesh Roy, and Justice Ajay Rastogi, former judges of the Supreme Court, for gracing today's event. Our sincere thanks to the sitting judges of various high courts for gracing today's event. Our thanks also extends to former Chief Justices and judges of various high courts who have graced this occasion. We extend our sincere thanks to Shri Vikas Singh, President, SCBA, the learned Additional Solicitor Generals, and all other eminent senior counsels for their gracious presence. A special word of appreciation for Shri Ram Panchu, Senior Advocate, a dear friend of late Ashok Desai, who has traveled all the way from Chennai to be amidst us. We acknowledge the gracious presence of the office bearers of SCBA and SCORA. A special word of appreciation for Ms. Pragya Vagel for her assistance throughout and in helping us making this event a grand success. We also acknowledge with appreciation the efforts of Shri Deepak Chauhan for legal logistics support and videography of today's event. We express our sincere thanks to LiveLaw, Bar and Bench, and Leaflet for the live broadcasting of today's lecture, enabling a wider audience to benefit from these enriching deliberations. We also are grateful to Ms. Ashmi Mridul for designing the e-invite and the banner. Our heartfelt thanks to the family members of late Ashok Desai, Shri Harsh Desai, Shri Jay Desai, and Srimati Ami Desai, and his sister Srimati Smita Diwan, and her son and daughter-in-law, Shri Sham Diwan and Madhvi Diwan. A special word of appreciation for Ms. Madhvi Diwan for taking initiative in setting up the stage. We also acknowledge the gracious contribution of the members of the chambers of late Ashok Desai. First, from the Bombay Chamber, Shri Nitin Thakkar, Senior Advocate and President of the Bombay Bar Association, for his gracious presence. From the Delhi Chamber, Justice Pratik Jalan, Ms. Shri Pallav Shishodia, the man behind today's event, Shri Ritin Rai, Srimati Maneka Guruswamy, newly elected Member of Parliament, Shri Darpan Wadhwa, Shri Rajan Narayan, Shri Ashish Wad, and Vikram Mehta for their contribution in making today's event a grand success. We express our sincere thanks to Ms. Shalini Shishodia. I think I forgot Krishnan Venugopal. As a member of the chamber, I'm sorry for. We express our sincere thanks to Ms. Shalini Shishodia and the spouses of the members of the chambers of late Ashok Desai for their generous contribution in making today's event a grand success. Lastly, and most importantly, we extend our heartfelt gratitude to the august members of today's gathering, dear friends of the bar, family and friends. Your gracious presence have truly lent depth and meaning to the deliberation this evening. We do not have enough words to thank you for your kind presence that has led to making today's event memorable and successful. A full house today undoubtedly is a testament to the enduring legacy and goodwill of my revered senior, Shri late Ashok Desai. Thank you, everyone.